In our series of lectures on international law, we just want an interruption due to receiving some important Supreme Court judgment on right to property. And as almost we know that the original Constitution of India, which was enacted in 1950, provided every individual the right to property. So also under Article 19 Clause F, it clearly provided the right, which is a fundamental right regarding acquiring, holding, and disposing of one's property at one's own wish and will, and also Article 31 of the Fundamental Rights provided right to property, but as it was removed under 44th Constitutional Amendment Act of 1978, it was no more a fundamental right, and instead of that, under the 44th Constitutional Amendment Act 1978, a new article was inserted as Article 300A, which speaks about that it is only a kind of human right and also a liberal right, and it would be considered as a legal right. And instead of that, as it was removed as a fundamental right since 1978, and it provided sufficient and absolute power to the government or the state to acquire any private properties of individuals. But on the 5th of this month, 11 2024, Supreme Court delivered a judgment which created the most sensation in India and also into the Constitution, as the Supreme Court rules that not all private properties can be acquired by government under Article 39 Clause B. So, in the very landmark ruling, the ninth judge bench of the Supreme Court has determined that not all private properties can be taken over by the state under Article 39 Clause B of the Indian Constitution. So the judgment clarified that privately owned properties do not inherently qualify as material resources of the community as it is being provided under Article 39 Clause B, and therefore cannot be acquired solely to serve the common good. And Chief Justice of India, Dhananjay Jasavanta Chandrachud, authorizing the majority opinion, stated that including all private properties as community resources, as it is defined and provided under Article 39 Clause B, would enforce an overly rigid economic model that emphasizes extensive state control over private resources. This interpretation, the court ruled, goes beyond the constitutional intent of fostering equitable resource distribution. As Article 39 Clause B mandates that the government should direct policies to ensure that material resources of the community are distributed to best serve public welfare. However, the court said that states may claim certain private properties in specific cases if they align with this code. The verdict, backed by the presiding judges of the apex court or the Supreme Court, such as Justice Harikishan Roy and Justice J.B. Pradiwala and Justice Manoj Mishra, Justice Rajesh Bindal and Justice S.C. Sharma and Justice Augustine George Massey overturned several post 1978 judgments that led toward socialist ideas permitting states to acquire all private properties for the common good. Only Justice B.B. Nagarathan issued a partial dissent on the majority judgment, while Justice Sudhanshu Dhulia fully disagreed with the majority judgment of the constitutional bench of the Supreme Court, providing a separate opinion on all points. This decision concludes a long-standing case initially filed in 1992 and referred to a nine-judge bench in 2002, which aimed to clarify whether privately owned resources could be included under the term material resources of the community for equitable distribution. So, as provided under Article 39, Clause B, all the private resources, which includes all private properties, as material resources of the community, and it could be utilized for public purposes or for public welfare, as it was held since the post 1978 Constitutional 44th Amendment Act. So, as it was held in all those previous judgments that the state could acquire all those private resources within which private property also falls, for the very consideration that it comes within the definition and meaning of Article 39 Clause B as material resources of the community, so it could be acquired by the state or government for public purposes or for public welfare. So this decision delivered by the nine judgment, this is a constitutional bench which delivered the judgment on 5th November 2024. The constitutional bench headed by the present Chief Justice of India, Dr. Dhananjay Jaswant Chandra Chudha, overruled all the post 1978 judgments. And why a majority held it that all the private resources and right to property or private properties do not fall under Article 39B as material resources of community. So the state or government could not acquire private properties by showing that such acquisition of private property as material resources of the community for the public purpose or public welfare. So, definitely, it is a landmark judgment delivered by the nine bench constitutional bench headed by the present Chief Justice of India, D.Y. Chandrachud, who is going to demit his office of Chief Justice of India on 10th November. So, this should be definitely a gift to Indian citizens as because the long standing controversy which raised due to the 44th Constitutional Amendment Act of 1978 and also due to the provisions and the very definition of right to property as it was, we found under Article 39 Clause B, and it was overturned by this judgment delivered by majority of the nine constitutional bench of the Supreme Court.